So if you asked a lawyer, it's a little bit of inside baseball here. If you asked a lawyer a few years ago what's an LLM, that's a fancy lawyer. So the regular lawyer just has a JD degree. If you're a fancy lawyer, then you have an LLM degree. So there are lawyers out there with the LLM degrees. I'm not one of them. I'm not, just a regular one. So we'll talk about large language models, which is what most engineers would say LLMs stand for. And particularly a case called New York Times versus OpenAI, which is less than 3 months old. And mostly about I think what's going to be the key legal issue that's going to determine it, which is fair use. And then if we have time, we can talk about some peripheral issues. There's also a case that was filed a couple of weeks ago by Elon Musk against OpenAI. And some restrictions on non-competes that states and the federal government are trying to get started. If you have questions, just ask me during this. The talk is flexible. The stuff at the end we don't have to get to if there's not a lot of time. So I have a technical degree. There are 2 people who work with me. One works with me in IP and another on free speech issues. I kind of do both IP and free speech matters. We have a mixed audience here of technical and non-technical people, so maybe just a little bit of terminology about what this all means. AI has been used over time to refer to various things. Early days, it was just decisions that mimic what people did. Then it got started applying to recognizing things, pattern recognition. So for example, noticing if something in an image is one way or another. What's new about this from a copyright perspective is that the newest version of it, or the newest iteration, actually generates content that in either text or images that would normally be the subject of copyright protection. So if you look at the older, like if it's telling you that's whether an image has some object or not, that's just a decision. The output there is not really subject to copyright. In the new ones, you have output that actually looks copyrightable. But from a user perspective, I actually think the search engine is the more relevant analogy because it helps you find information. It's technologically not quite the same thing, but for me as a user, these things help me find information. So some of the case law actually comes from search engine. The way this infringement, so New York Times about 3 months ago filed a copyright infringement against OpenAI, alleging that basically the whole model of the current iteration of AI infringes their copyrights. And what the lawsuit will likely, what the arguments will be is, New York Times will go there and say, you infringe our copyrights. And that's a somewhat easy argument. And then OpenAI will come back and say, well, actually what we're doing is fair use, and that they will have to prove that. And there are 4 factors that courts look at. The most important one is, what's the effect on the original market? So in this case, New York Times' market for selling news and whatever content they sell. So there's some earlier cases on fair use in earlier contexts. In this case, it was Google's image search. So there's a company called Perfect 10 that sold these magazines, and you could go online on Google image search and find their images on various websites. The company didn't like that for obvious reasons, but they couldn't really sue the distributors of those images because they probably were not in the US or they were judgment proof, they couldn't find them. But Google was available. So what they said, well, let's try to go after Google for providing access to these things. They could have tried a couple of things. They could have said, we're going to try to sue Google for providing the tools for doing it. That's called indirect infringement. But they couldn't really do that, or they would have trouble doing that, because Google image search can also be used for many other things that don't infringe. So, there's an older case about the VCR. The VCR could be used to make copies, illegal copies, but it could also be used for legal things. And if that's the case, you can't really blame them for selling the tool. And Google was also not specifically targeting infringing material. They were just scraping everything online and displaying it, so they couldn't sue them. They couldn't argue that they really encouraged this infringement either. So what they tried to do is to say, well, it's not just that you help these guys infringe. It's that your display of the little images of the previews, of the downscaled thumbnails, that's actually infringement, because you're making unauthorized copies of our images, and that infringes. The court said, no, these things aren't really substitutes for the big photos. They have a different purpose. It's transformative. They help you find the photos, but they're not a replacement for them. So they said that's fair use. In this case, this was last year, if you might have heard about it. This was not fair use. So there's a photographer called Goldsmith who had taken a photo of Prince. And then Andy Warhol made a number of, derivative works, let's say, that used the photo. And the court there said, yeah, it's changed a little bit, but it's not really transformative, because this is a substitute for that. It's close enough, they're both selling photos, it's going to affect the market. This is not fair use. Okay. It's a more technical case, but that probably the engineers in this room know about. When Google started developing Android, they wanted developers to be able to develop code for their new platform. And so they wanted to reuse the Java function calls. They wanted the engineers to be familiar with the language so they could write code more easily. So they just copied all the function names in Java, but not the underlying implementation. The code, they rewrote themselves. But all the function names were identical. String compared to, string compared to. It wasn't like, and you go across the functions. And if you're a developer, that's great. You can write code and you already know what everything is called. If you were Sun and later Oracle, they were not happy about this. So they sued, and it went to the Supreme Court. And the Supreme Court said, actually, this is transformative and it is fair use. So that's another example. One that's probably more relevant, or pretty relevant to the AI debate, is a case on anti-plagiarism software. So here, these students were running a paper mill. They would sell their papers to college students. And anti-plagiarism software was putting a damper on their business, because they could sell a paper only once. Without the anti-plagiarism software, they could sell it and then sell it again. But with this, once they sold it to one guy, they'd have to write a new one. And this was damaging their business. And the paper was their content, so they wanted to they wanted to tell the anti-plagiarism software company to knock it off and stop making unauthorized use of their papers. And the court said, no, actually, this is transformative. It's fair use. Even though you're not really changing the paper, you're using them for a new purpose, and therefore, you don't have to pay the original guys. You can tell whether this is plagiarism or not. And finally, Google Books. Google displayed snippets of the books they had scanned, but not the whole book. And then you could link it, go to a publisher to buy the book if you wanted it. And they said that's fair use. That's okay. It doesn't really compete with with the publisher's book sales. You can do that. But if you try to, like Internet Archive did, if you actually e-lend the books, that's not fair use, because that's competing with the publisher of the books. You won't buy the book if you could just check it out in the Internet Archive. So this case is the New York Times versus OpenAI has gotten attention because it probably affects everybody working with these large language models. That, it's not just OpenAI, it's everybody who uses training data probably uses to some extent some copyrighted material. That's the way these things work. You feed them a lot of stuff, and it's hard to avoid. If you just use material from the 19th century or whatever is in the open domain, your model will give you funny outputs. It'll probably speak like somebody from the 19th century. So they want to be able to use data that's under copyright, and the New York Times doesn't like that. So they sued. I actually worked with the head lawyer on this. I know the guy. He's a smart guy. They have a good team, and they allege several things. Copyright infringement is the main one. They also have some peripheral claims that I won't really talk about. But basically, one is about removing copyright notices, trademark, and a state law claim. These are, I won't spend time on those. Those are kind of not that important. The core claims are the copyright claims. And the New York Times paints OpenAI as a competitor. And maybe they're right. I mean, if ChatGPT is going to put New York Times journalists out of business, maybe they are a competitor. But this is one of the arguments that they're going to fight over. They say basically ChatGPT competes with and threatens Times' ability to provide their service, and that ChatGPT is a substitute for New York Times. That's their argument in court. And it's relevant to the fair use factor. They say also that the outputs of the model compete with and closely mimic the inputs. So the inputs are the New York Times article that were used to train, and then the outputs are whatever ChatGPT tells you. They're saying that they can be pretty similar, and in some instances they can. They give 100 examples in an appendix of outputs showing copyrighted content. So in this case, they call the behavior memorization. If you start with a beginning of an article, of a story from the New York Times, and you feed that as your input, ChatGPT will give you the rest of it. Now, how much of it you have to feed it is kind of case dependent. Yeah, go ahead.
Well, also they're stochastic models, so it depends on how much entropy you're getting and what your seed is. But.
Right. No, so it will depend. In certain instances, this is a particularly short beginning. Sometimes you might have to feed it more than this in order to get the whole thing. It depends also how long the story. Their point is, though, they don't have to prove that everything infringes. They just need to be able to show that some of it infringes in order to try to get some compensation. And that's what they're pointing to this problem. And they're basically attacking all three levels at which I think you can conceptualize the problem. So they're saying you infringe when you train your model. That's funny because Google Books and the anti-plagiarism case and all these other things actually say that you can use, in fact, copyrighted material. If you put it to a different use, then you don't infringe. So this is, with a caveat, this is an argument that might have some, where at least the fair use defense might have some problem. But there's an asterisk, though. We'll get back to that. Their second argument is that the model itself, the weights, and basically the software, even though you can't see the book in there, but you can ask it, and if you ask it correctly, it'll give you the book. So the book is in there somehow, even though it's encoded. So in a different context, let's say you had a movie or a book, if you just encoded it with some kind of format, MPEG, or you encrypted it, it's still the book, even though it's changed. You can't read the letters on it. So that's the second argument. The third one, and this is probably the big one, is that the output infringes. We'll see. It doesn't infringe all the time, but just if it infringes some of the time, that they'll say that's good enough for them. So one question that I'm sure they will argue about is, what is the market? This is, to the antitrust people, this is a familiar question. And the antitrust guys have some ways of identifying when something's one market or two. For example, if the market for ground beef and steak affect each other, if ground beef gets expensive, something happens in the steak market and the other way around, maybe there is a combined market for beef and not separate markets for ground beef and steak. So there are tools economically. It's something called cross-elasticity of demand, I think, if I remember right. You can identify if it's one market or two. And here, the New York Times says the market is providing information, and both OpenAI and New York Times are in that market. OpenAI's position is, no, we're a different market. We provide AI content. You guys provide human-generated content. It's different markets, so we're transformative. This is the wrinkle about the input part. Apparently, there is an active market for licensing content for training. Some people pay for this. And OpenAI said, we don't want to pay for it. What this does, though, is this creates an argument that the first level, that you infringe in that first level in this case, because you affect the market on the input side when you use copyrighted content without paying for it. And a small secondary thing is New York Times has a service called Wirecutter. They write product reviews, and then they get a kickback from links from that. And they say that ChatGPT, because it doesn't have those affiliate links. But that's not that important. It won't affect many other people. It just affects that specific business they have. This is just a tidbit. It's not, I think, critical to the case itself, but apparently in an interview, the CEO of Microsoft is an investor, and they're closely linked to OpenAI. They said that if OpenAI were to go away, Microsoft would just carry on without any problem. So where's the case now? There are basically two motions to dismiss that have been filed. They're on ancillary issues. They're not going to decide the case. Because fair use is fact intensive, this is probably going to be resolved. It's going to take over a year or two. It's going to go to summary judgment. It's unclear how long that's going to be, but it will not be resolved anytime soon. One thing that caught my eye is that New York Times is asking not just for money, but they're asking ChatGPT to be deleted. We'll see if that flies, but that's one of their requests. So where this is going to go, I don't know exactly. But one thing that may resolve this is that people will just have to pay for the training data. And if it's sufficiently inexpensive, maybe it won't be a problem. And that's the way to share the extra wealth that's being generated here. On the output side, the technology is there to check for plagiarism. So you could have some kind of anti-plagiarism filter. Maybe that's the way to handle the output side problems. You just put a filter there, and if it looks too close to what's already there. Now, I don't know if that's, again, economical. Like how already a ChatGPT query costs tens of cents. So when you query the Google search engine, that's probably 100 times cheaper. It's not a lot of money. When you ask ChatGPT to do something, it's if it's 50 cents or $1, that's substantial. If you have to add anti-plagiarism now on that, I don't know what the economics of that is, but conceivably this could be expensive. So if we have time, how much time do we have? I'll move over pretty quickly over this. About 2 weeks ago, Musk sued OpenAI in San Francisco. There's an interesting history here. There's a meme exchange. I don't know if you can tell. Vinod Khosla and Elon Musk are, quote tweeting each other, fighting over this. Elon Musk gave money to OpenAI in its early days, and said, okay, now it wasn't an ownership stake. It was basically a grant. And OpenAI said, we're going to be a nonprofit, or we're going to open source everything. And then a few years later, they said, well, in fact, we want to be for profit. And they went to Musk, and he said, no, you either do something on your own or continue with OpenAI as a nonprofit. You know, I don't want to provide free funding to a startup, basically under the guise of, you know, charity. Musk has a problem, though, in that I don't think there was a written agreement about this. This is just what they discussed. So he says, well, we had a deal, and it was memorialized in the founding, in the certificate of incorporation of OpenAI. That sounds like a funny way to memorialize a contract, but that's his argument. And you know how that's going to go, again, I don't really know. OpenAI has a weird structure. It has a 501c3 public charity that controls a for-profit company. And Microsoft has a deal with a for-profit company. So when Satya Nadella was saying, oh, if they go away, we're all okay, he was talking about the fact that they can use this technology, but which is really controlled by this. Somebody who knows more about nonprofit law can figure out if this is all okay or not, because I don't know. But there are restrictions on nonprofits giving away their assets to for-profit companies. And it's not my specialty, so I don't know what's going on here, but this looks really strange. Yes. So just very quickly, I'm going to summarize this. I won't go into the details. The Jimmy John's sandwich place, the sandwich artist restriction on working for 2 years somewhere else, because you might disclose, that's an older thing. They dropped that. But it was a poster boy for people saying non-competes are kind of going too far if you're trying to restrict the employment of sandwich artists. And so there's a federal proposal right now to ban non-competes nationally. Right now they're they're not enforceable in California. And the federal government might have some trouble with this because there are limits on what the executive versus Congress can do, and this might be more than the executive can do. Like you may have to have Congress step in here. But even if that's the case, there's a lot of activity and bubbling into trying to restrict non-competes, and it's happening. Several states have passed laws, and California has tightened its law on non-competes now to extend it to other things that are non-competes, like non-competes, like non-solicitation. And final slide. This is just a little bit of funny theology. There are people out there who are seriously spending money on trying to get AIs to be recognized as people by governments, and they're doing this in the context of patents. They're trying to say, we've developed this new technology, and actually this piece of software is a co-inventor. Please recognize this person as a person who invented something. And both in Europe and the US, the governments have said, no, you know, it's just a tool. It's not an inventor. So anyway, that's it for me. Thank you.